May it please the Court, my name is Bill McCabe. I represent the claimant Suzanne Deer. I'll reserve a minute and a half for rebuttal. In this case, the Judge of Compensation Claims found that the claimant's petition for various medical and indemnity benefits was barred based on the statute of limitations. We submit the judge erred because of the claimant's estoppel argument. The carriers have stopped from raising the statute of limitations. This case has been before this Court before. This Court previously remanded this case, instructing the judge to make determinations as to whether or not the employer carriers have stopped from raising the statute of limitations. This Court also stated in its original opinion that in order for estoppel, claimant has to show three things. One, that the employer carrier misrepresented a material fact. Two, that the claimant relied on the misrepresentation. And three, that the claimant changed her position to her detriment because of the misrepresentation. This Court also said that where an employer carrier misleads a claimant about his or her rights or availability of workers' compensation, even unintentionally, resulting in claimant's failure to file or timely file a claim, then the carriers are stopped from denying benefits. In this case, the judge found that two of the three elements were met. The judge found that the carrier did misrepresent a material fact when they told the claimant there was nothing more that they could do, or they didn't know what she could do when she asked for further medical treatment after her authorized doctor wouldn't see her anymore because she had been involved in a subsequent motor vehicle accident.
You're essentially arguing in this case that undisputed evidence that a workers' comp claimant has, number one, knowledge of his or her right to medical care and indemnity benefits, and number two, has availed himself or herself in the past of that right, will not necessarily overcome the estoppel claim.
Correct.
I mean, believe me, looking at our case law, I can completely understand how you'd make that argument. But I'm really trying to focus on the statute. And I'm trying to understand where in the statute employers and carriers are instructed that as part of the information they must give claimants, one part of that information is a detailed explanation of how the statute of limitations works.
Well, it doesn't necessarily that they have to give detailed explanation of how the statute of limitation works. The statute 440-185, I think it's 3, it's the one that requires them to send out the information, it's 4, excuse me, that says they have to send out the informational brochure. It does state that they have to set forth in clear and understandable language an explanation of the rights and so forth for the claimant.
What is that? I mean, the debate, as I read these cases, seems to be a line of cases that says, well, the rights means that you've got a right to medical care and indemnity benefits at the expense of the employer.
Well, all these claimants know that they've got, or it seems to know that they've got a right to medical care, but they just don't know how it ties in. For example, where this claimant did not understand her rights, and that's what the case law says from this court, is that if the claimant can establish that she was not advised of rights or information that precluded her from asserting those rights, then she can raise the estoppel argument. But the rights this lady didn't know is she didn't know about the statute of limitations. She also thought she had to go through the carrier every time she wanted to see an authorized doctor, which is contrary to case law. Once a doctor's authorized, the claimant can go see the doctor without getting reauthorization from the carrier. She didn't know any of those things. But this case even involves a further element, and that is that in this case the carrier overtly told this lady that they didn't know what else she could do, when there was plenty of things that she could do. She would have been entitled to an IME. She could get treatment for the part of her injuries that the accident caused. She had a permanent impairment rating. She was entitled to ongoing palliative care. And so the issue in this case is, did this lady rely or change her position to her detriment because of the misrepresentation? That's the element the judge found that she didn't prove. And the lady testified, unrefuted, that had she known that she had to see a doctor every year, she would have done it. I mean, there's the reliance upon the misrepresentation. Now, what the judge does in this case is takes judicial notice of the informational brochure. No one asked her to take it. She states that all the brochures since 1996 talk about the statute of limitations. Well, that's contrary to claimant's testimony. She said she saved it. It was never placed in the record, but she said it didn't explain it. The adjuster said, I don't know, and the adjuster quite frankly stated that the brochure has been changed in the last few years.
Well, are you arguing, though, that no matter how much the claimant knows about Chapter 440 and her right to medical indemnity, if she actually doesn't know about the statute, that lack of knowledge can somehow overcome everything else?
Well, when this case was remanded to the judge, the sole purpose of the remand was to determine if the estoppel argument applied. And the court laid out the three elements. The judge found two of them. The third element was, did the claimant change her position to her detriment because of the misrepresentation? That's really what this whole appeal is about. And we submit that the only evidence in this case establishes that she did change her position to her detriment because the carrier told her they didn't know what she could do. Plain and simple. And based on that misrepresentation, the claimant didn't do anything until eventually she saw an attorney, unfortunately, after the statute of limitations ran. So that's the sole issue in this particular case. And the case law does say that if there's Crutcher versus School Board of Broward County, it's cited in the brief. Tallahassee Memorial Healthcare versus Coleman says that the judge, if a claimant lacks actual knowledge of any other pertinent right under the workers' compensation law, and if so, whether such ignorance accounted for her failure to obtain care during the 2 years following her last visit to Dr. Loeb, that's out of the Tallahassee Memorial case. But if they lack pertinent knowledge, then the estoppel argument can't apply. She did lack pertinent knowledge. In fact, she was misinformed overtly. And
well, she knew she had the right to go back to a previously authorized physician because apparently she did, but this doctor, for whatever reason, refused to treat her because she had another accident. And she says the reason she went back was to find out if any of her present complaints were related back to the industrial accident. How does that play into this whole thing? Well,
even though she knew she could go back, she also thought that she had to go back through the carrier. That's what her testimony is. She says you can't just go back on your own. That's what she thought. So when she calls the carrier after the doctor won't see her, and they say, "We don't know what you can do," what is the lady relied upon that? She didn't know what she could do. She didn't do anything. That's the reliance on the misrepresentation. I'll save the rest of my time for rebuttal.
Thank you.
May it please the Court. My name is Ben Crystal. I represent...
Mr. Crystal, I got to ask you, because when I read this order on remand from a experienced JCC applying a concept that's fairly common to civil lawyers, estoppel, I found myself wondering how the claimant could demonstrate reliance, which seems to me you can't. And if you rely on something, by definition, you have changed your position, and then fail to demonstrate the third element of estoppel. I'd like you to explain to me how that could be.
Certainly. Actually, the third element of estoppel, the detrimental reliance portion, I think is actually spelled out quite clearly by the judge in her order. And in fact, there is one thing I'd like to point out. I think that appellant in her brief confuses a couple issues. She talks about the misrepresentation of the employer carrier for elements 1 and 2 of the detrimental reliance or estoppel argument, but for the third element of detrimental reliance, she reverts back to her knowledge of the statute of limitations. That particular knowledge issue has nothing to do with the detrimental reliance issue. The detrimental reliance issue never is argued by Ms. Deere that she...
But you know what bothers me about this this is an interesting exercise, but when you look at pages 10 and 11 of the order, at pages 403 and 404 of the record, and you've read it many times, I'm sure, preparing for this OA, anticipating this question, the evidence that the judge accepted indicates that the claimant, the carrier's representative, said there's nothing we can do for you now. Why wouldn't that be sufficient to override her supposedly prior knowledge of her general right to medical care?
Well, first of all, that particular representation was made in the limited context of a follow-up appointment with a neurosurgeon. The neurosurgeon refused to see her. I'm not even sure what the carrier is supposed to do there anyway. If the doctor's not seeing her, well, what are they supposed to do with her returning back to see Dr. Shoemaker?
Do you want me to answer that question for you, or is that rhetorical?
That's rhetorical.
Okay.
I think what's more important is that she was aware, and she even stipulated in the pretrial, that there were a number of physicians authorized, to include Dr. Keene, to include Dr. Lovett, to include Dr. Cassidy. She never made any attempts to go back to see any of those doctors, and that's the, I think, crux of the judge's ruling that the claimant did not meet her burden on the third element of detrimental reliance. She never made any attempts to go back to see those doctors, and the reason that she did was not from the misrepresentation made by the carrier, but because of a unrelated issue involving her knee. She, in fact, characterized her work comp injury as being trivial, as being something that she doesn't sweat the little things, referring to her workplace injury, because she's dealing with her knee injury and all of the emotional problems that raised for her, of being able to support herself when she's in the hospital, of being able to deal with her father having lost his leg in World War II, and all of these issues came to the forefront, and she, when asked why she never followed up with any of those doctors, that's the reason that she gave. She didn't say because my understanding was that I couldn't see a doctor again.
That was all of record when this case first came up, and you know that, and I know that, and we've all read the first case. That was all of record. Yet this court said, we're going to go back only on the question of estoppel because she's made a prima facie showing, at least in her pleadings. I understand your factual argument, and I understand your suggestion that there's all kinds of CSE in this record to show why she didn't seek medical care. Perhaps she just didn't need it. But what troubles me, what gives me concern, is that this court sent this thing back on estoppel, which suggests to me that that prior panel had some sort of a feeling about this case.
Well, my understanding of that original remand was that the judge didn't really explain the issue of estoppel in her original order. There was an issue of a misrepresentation, which automatically rings the bell that there might be an estoppel argument here. Then what this court asked the judge to do on remand was, let's now consider that estoppel argument and weigh it with those three elements. They didn't weigh those three elements in the appellate decision. They asked the judge to do that. The judge went back and did that and came up with her ruling that the claimant did not prove by clear and convincing evidence, which is a heightened standard, that she detrimentally relied on that.
See, I guess if you were arguing that this claimant was in the same position every other claimant's in, which is that she had an industrial accident, she had a period of treatment, she reached MMI, she had a permanent impairment rating, and she thought she needed more care, well, heck, she's in the same position as every other claimant. She can pursue her right to care right up to getting a lawyer and filing a petition. If that were the issue, I think this would be a PCA. But something in that first opinion tells me that's not the issue.
Well, at the same time, though, the detrimental reliance of a statement, I'm not sure what else you can do, is the defendant supposed to inform the plaintiff that, well, they can file a petition for benefits, well, they can pursue it before a judge, well, they can request a second opinion. I mean, I don't think that's an affirmative obligation on the employer and carrier in a work comp case to let them know of all those different rights that they have. She admitted to having received the informational brochure. The judge found, as a matter of fact, that she did have knowledge of pertinent rights under workers' compensation law, and simply by stating that, well, I'm not sure what else to do with you, that this particular doctor won't see you again, the record is fairly clear that she did not show how she detrimentally relied on that statement.
Is there any evidence in this record, any suggestion in this record that this claimant did in fact have work-related injuries that required treatment either in January of 2001 when she visited the doctor or when she filed this petition the next year? Is there any evidence that she had a work-related injury for which she needed treatment?
Yeah, I mean, I think the facts, it's stipulated that she had a compensable injury. She had authorized medical care. She received treatment. She received primarily chiropractic care.
Now, my reference is to the time that she was seeking this additional treatment. At the time the statute...
Well, right. At the time she sought the additional treatment, Do you mean when she went back to Dr. Schumacher?
Yes.
Well, she had already had her subsequent motor vehicle accident. She had already been released to return to work from her workplace accident. She'd been placed at Max Medical Improvement, had been given a full-duty work release by Dr. Cassidy, has her motor vehicle accident. Suddenly, she's completely off work. She's in need of attendant care at home to do her house cleaning, her lawn mowing, her everything else, her pet care, and she's requiring further chiropractic care. She knew enough to go back to see Dr. Keene after her subsequent motor vehicle accident. There's no reason that she shouldn't have known to go back to see him or Dr. Lovett or Dr. Cassidy if Dr. Schumacher wouldn't agree to see her any further. And I think that's the limited issue that was being addressed by the carriers, that, well, what are we supposed to do? Force Dr. Schumacher to see you? We don't know what else you can do in that instance. Well, what she could have done is went back to one of the other doctors that she was authorized to see and she had been seeing since the onset of her injury.
What I'm saying is that if we were to reverse this case, do we know, and of course Mr. McCabe can respond also, do we still need a hearing, or do we know whether or not she in fact has some sort of continuing compensable injury?
Well, that's actually one of the issues. One of the defenses in the original hearing was that she had a subsequent intervening accident, and I think that the Sherwin-Williams decision would make there an issue of fact as to whether or not there should be apportionment involved because of the subsequent accident.
Well, you're saying we don't know the answer to that question.
We don't know the answer, and that's an issue of fact that would need to be addressed by the judge again, as to whether or not any further medical care would be due from the workplace accident. However, I think that while I understand the court's concern about how you apply the third element of detrimental reliance in a work comp case like this, I think the judge laid it out excellently in her order of how you actually do that. She came up with legitimate evidence, record evidence, to show how she didn't detrimentally rely on that, but she apparently had other issues going on in her life as being the reason why she never pursued a work comp claim, as opposed to her the nature of the injuries from a work comp claim, which there's no evidence that she even had any intention on following up with at any point anyway. The only reason she went back to see Dr. Schumacher was to see what effect her subsequent motor vehicle accident had on her original workplace injuries. There's no evidence she ever had any intention on following up to see another doctor, aside from her attorney asking her if she would have, and she simply just says yes. Aside from that, all of the treatment that she required following her subsequent motor vehicle accident was clearly related to that issue, was paid for through that subsequent motor vehicle accident, not through her workers' compensation injury. Therefore, I think that the record has more than sufficient competent substantial evidence to support the judge's second final order on this issue. Thank you very much.
To answer your question, the judge made a specific finding that if it wasn't for the statute of limitations, she would have ordered an IME to determine the causation of claimant's current complaints. Did she need medical treatment at the time? Well, number one, that's what she was trying to find out, but number two, she had a 6% permanent impairment by one doctor, 7% by another, 10% by another, and one of them, Dr. Keene, put limitations and restrictions on her. So with a permanent impairment, there's obviously something ongoing that's still wrong with her. Workers' comp is still a system where the carrier is supposed to timely provide needed benefits to the claimant. And when a claimant calls up and the doctor won't see her, it's real simple what the carrier should do. Send her to a doctor that will see her. Send her to the IME. That's what they should have done. Now, this stuff about authorized doctors, too. Again, claimant was under the misunderstanding that she had to go through the carrier every time she wanted to see a doctor. In actuality, she really didn't even have any authorized doctors anyway, because Dr. Lovett was the first doctor she saw who referred her to the neurosurgeon, Dr. Shoemaker. Dr. Shoemaker wouldn't see her anymore because she had the motor vehicle accident. Dr. Cassidy saw her one time for a second opinion, and Dr. Keene was a chiropractor who treated her 25 times, which is already in excess of the 18-time maximum under the statute. And finally, again, we're down to the detrimental reliance. The claimant specifically testified that had she known about it, the one-year restriction, she would have gone to a doctor. Is my time up? Yeah.
Have you actually got 5 minutes?
I do? Oh,
On
okay.
my clock, anyway. Is
Well-
that right, Janita?
I think I've pretty much said
As much as you need.
You can always,
Say thank you.
roll over minutes, Mr. McKay. You may need it next week.
Want me to repeat myself yet again?
Thank you.
Thank you very much.
Thank you. Thank you, counsel. As I mentioned earlier,